Right, a very good afternoon, East Africa, ladies and gentlemen, wherever you are joining us from. I would like to welcome you to this very special webinar edition discussing banking on transformation. And today we are empowering East African lawyers to lead the future of finance. And as you know, banking and finance is one of the most growing or emerging areas within the region, with international banks beginning to set up a base in Eastern Africa. And as lawyers, we play a very fundamental role in this move. And this afternoon, we are esteemed to have a very competent panel of experts drawn from across Eastern Africa. These are the best brains on this subject, and we are mostly privileged to have my good friend and sister moderate this session. Our moderator is a comprehensive banking and project finance practitioner who has experience that has ranged from advising international finance parties to local project companies on a variety of transactions, falling largely under the power sector. She has over 6 years experience and she has gained appreciation in this area of finance and project for companies, project finance transactions. And she serves currently as an associate with the banking and finance team at ALN Uganda, which is Max Advocates Uganda, one of the leading law firms in Uganda. Ladies and gentlemen, I'm speaking about no other than Priska Naguja, my good friend. Good afternoon. I hope you're doing well, Priska, in Kampala. I'm very honored to have you this afternoon, and your panel is ready. Your participants are ready. They're streaming live on YouTube and streaming live on Zoom. And so you have about 2 hours to have this very wonderful conversation. And this conversation comes in quite timely because the East Africa Law Society is organizing the largest gathering of in-house counsel from across Eastern and Southern Africa in Kigali, Rwanda, under the auspices of our in-house counsel committee. And the event is dubbed the ESC In-House Counsel Convention that will be happening in the month of August from the 28th to the 29th of August. And we encourage all banking practitioners that are on this call to check our website and register for that training. Remember, the session is happening on the 28th and 29th of August, 2025 in Kigali, Rwanda. And so as we kick off this conversation, banking and finance is one of the topics that we'll be discussing during the in-house counsel convention. So at this juncture, this is more like the precursor of what will be discussed during the in-house counsel convention. So Priska, I'll hand it over to you now, and you can now take on this discussion. Thank you.
Thank you, Gabriel. I hope I'm audible enough. Thank you for that wonderful introduction. I'm smiling because you've spoken so many nice things about me. I'm truly honored to have been given this opportunity to moderate this really important session. And as you've highlighted, it's really timely because the times we are living in are really speaking to the ever-changing landscape in legal practice as a whole, but also just in the niche practice of banking. There's a lot of change that's happening. And so it's timely because we need to always engage and regroup always to assess and ensure that we are actually at the top of our game and that change is not actually passing us by. So with no further ado, let's delve right into the presentations for today. I'll be your moderator, as Gabriel has mentioned. We have 4 great speakers today lined up, and the guiding theme for our discussion today is really banking on transformation and being really ready for the digital changes that are happening from the lens of us as being strategic banking practitioners in our respective contexts, whether you're in-house or in a law firm or in a government institution. I'm very sure that most of the conversations today will be very relevant and there'll be very important takeaways for each one of us. So we have 4 great speakers, as I've mentioned. And our first speaker is Miss Lois Erambo. She'll be leading us on a session themed under the title Sustainable and Cross-Border Finance, with a specific emphasis on the lawyer's role in structuring responsible and compliant transactions in this ever-shifting financial landscape. So a little about our great speaker, Miss Lois. She's known for her expertise in cross-border banking and finance, particularly within development finance, ESG-linked transactions, as well as compliance advisory across the East African countries. She's seasoned in her area, and she's really one of the best people that can speak to us about this topic. Miss Lois, you're welcome. Thank you for joining us today.
Thank you very much. I will put on my camera for a second just to say my hello. Just let me know when you're able to see me. Any luck?
No, not yet, Lois. Oh, now, perfect. Hi.
Thank you. Hi. Looking forward to this discussion today. Happy to talk. Thank you.
Sure. So before we delve right in, for our attendees, Ms. Lois will have a maximum 20 minutes to take us through this topic. I'll be posing really strategic questions to stir up our imagination and get the conversation flowing. After her session, we'll have a 5-minute Q&A before we proceed to the next speaker. And that will be the structure for the other sessions as well. And at the end of the 4 topics, when there's time to spare, we'll actually get back to the additional questions that the dear attendees will have. So, Ms. Lois, let's begin. Setting the stage for everyone in the room today, could you briefly define what this term sustainable finance means? Because it's cropping up, everywhere these days, and it's easy to assume that we have an understanding of it. So to start us off, please take us through what that term means and help us create a difference between sustainable finance and the traditional finance as we know it. Thank you.
Thanks, Krista. I think so. There's no standard globally accepted definition of sustainable finance, and I think the best way to define it is again a comparison to the traditional vanilla finance transaction. And basically, the difference would be that with sustainable finance is a move away from the traditional financing model, where profit was the primary goal. Sustainable finance is a quest to also consider the impact of our financial decisions and to integrate ESG considerations in making any financial decisions. So you'll see this is basically a move to integrate ESG from a decision-making perspective. You'll see it's even reflected from a governance perspective, coming all the way down to the financial products themselves, and of course, an assessment of the impact. So that would be the difference between a sustainable finance transaction and a vanilla finance transaction. So a move away from what used to happen. You remember at some point we had financial institutions and basically entities that are operating in the financial space would have some sort of foundation that would run parallel to the business that was not really integrated in its approach to sustainability. And now we are seeing a move away from that sort of approach to integrating sustainability right from the leadership to governance, to financial products, to financial decisions. So it's basically gelling these two together. And when we talk about sustainability, there's a tendency to hyper focus on the environmental aspect, but the scope is much wider than that. It's not just the environmental issues. We're looking at the social issues, socioeconomic issues, access to health, access to education, gender opportunities, gender-related opportunities, equal pay, things like that, all of those impact our decision and how we structure sustainable finance transactions.
Thank you, Lois. Before we move on to the next question, there's I think an issue that's been raised with regard to your audio. It's not coming through very clearly for the audience.
Sorry, can you hear me better now?
On my end, it's clear. Let me check with the organizer briefly.
Okay.
So, Ms. Lois, as the team is confirming that, let's proceed in the interest of time. I hope the audio will improve as we progress with the discussions. Thank you for setting the stage with that great introduction on what sustainability means and the fact that it's not usually supposed to only entail the environmental, although that's where we tend to actually direct our minds towards. So that's a really great introduction. So moving on to cross-border finance, just for the benefit of the younger lawyers and also the more senior lawyers, just as a refresher, how would you define cross-border finance in practical terms? And what makes that type of transaction a more complex one from a legal perspective? And feel free to, use examples where necessary. Thank you.
All right. So international or cross-border finance would it basically means just that that you typically have transactions that are implemented in various jurisdictions, and of course, because of the different legal systems that you would be interacting with, there's automatically some complexity around this. So in terms of products, I think a good example would be from a trade perspective, letters of credit instruments, for example. So you find a borrower taking a loan from a certain type of lender, whether it's a commercial lender within their country or an international, say, DFI or an export credit agency for purposes of, stocking the product and to finance the export the export to the seller in a different country, and of course you're looking at transportation. What would entail movement of products from one jurisdiction to another? What are the legal implications? What are the risks? How do you mitigate those risks? So I think from just with that understanding in mind, the interaction of different jurisdictions in other finance transactions would explain the complexities around structuring international finance transactions.
Thank you for that. Delving into this same question in terms of structuring, please provide some more guidance on what our role should be in order for us to drive more value in terms of either its deal generation or during the negotiation stage. In my personal experience, I find that documents will arrive and most of these terms are already pre-negotiated, pre-agreed, with the ESG components already, established therein. So is there room for a legal practitioner to actually have a voice at that stage of deal origination or documenting of the ESG components in a deal? Thank you.
Okay. So traditionally, as you rightly said, when a sustainable sort of an ESG transaction is being put together, particularly at origination stage, you'll find that the by the time the lawyer is involved, some discussions have already been had between the lender, possibly the arranger, and the borrower, just around the ESG issues, you see a lot of reliance on, because it's a whole ecosystem by itself. We have experts that are in that field. You see a lot of lenders or arrangers are engaging ESG coordinators or sustainability coordinators who help them with framing the KPIs or the sustainable objectives within a particular deal. So typically at origination stage, a lawyer's role is quite limited from a transaction perspective. It's very limited. However, I would say the value that a lawyer would add in a sustainable finance transaction would be bringing in your understanding of the sustainable finance product. You need to have a very good understanding. When people talk about a green loan, you need to know what a green loan is. How is a green loan different from a sustainability linked loan or a social bond, for example? All those comparisons, we need to have a very good understanding of the product, because that is going to build into how you're going to even draft your documentation and your understanding of the various parties that need to be involved in the process. So you see, once you really get into the meat of things, you'll see that putting together a sustainable finance transaction involves a lot of people and a lot of experts. So it's not just legal led. Legal is, I would say, a facilitator within a transaction. Outside of a transaction, you also have a role from a policy perspective, because there will be a lot of reliance on you from a policy perspective in shaping a lot of these ESG guidelines. You will see there's a whole ecosystem out there on guidelines, policies, standards. How do you verify? If I say a certain project leads to X% of reduction in carbon emissions, how do we verify that? Who will verify that? How do we guard against greenwashing, for example? So you need to have a wider understanding of this product in order for you to add value as a lawyer in this transaction.
Thank you, Lois. That was quite insightful. When it comes to aligning these deals, and as you may be aware, most times there's no straightforward application of our local laws vis-a-vis the international standards. So how would you typically approach such a conflict, especially in our economies where our laws haven't yet quite caught up with the ESG movement that has really caught fire elsewhere? How would you navigate that?
So what typically happens when in a transaction, particularly an international finance transaction, is we tend to rely a lot on international standards. So a lot of us that do this type of work, you see, we do have green loan principles that are usually proposed. Many of these standards are not binding. They are basically guidance for those that are operating in this space to sort of, I think the idea is to try and standardize the principles as much as possible. So you'll see, if you look at so just from a transactional perspective, globally and also of course within East Africa, we tend to rely a lot on the green or on the sustainability principles that are published by either the Loan Market Association or ICMA, which is basically the equivalent of loans, but now for bonds. So you see, if you do a simple search online, you might find the green loan principles. We have social loan principles. We have sustainability linked loan principles, that you need to understand item by item what the requirements are, because that you're drafting and your structuring will be centered on the globally acceptable principles. However, that doesn't mean that you ignore your local law provisions. Remember, we're talking about cross-border transactions. In the various jurisdictions, now you have binding principles that you need to comply with. So there's a compliance aspect that comes in when you're dealing with domestic law. So I would say for international finance transactions, there tends to be a collaboration between international suggested standards that are widely accepted, and of course your domestic laws that tend to generally be binding in nature that actually are a compliance issue, and you need to ensure that all those requirements are met.
Thank you, Lois. That was quite insightful. I see our time is fast spent. I think in closing our session for now, of course, at the end, we'll come back if time allows to have further questions directed to you. But in closing, speak to the lawyer in the law firm, speak to the lawyer who is in-house or in government, and help us understand how we need to position ourselves to, advise better and bring more value to clients, especially the ones that we represent in these cross-border deals. For the law firm, especially, we tend to have a one-way mindset that this is how things are supposed to be done. This is the template we have to use. And also vis-a-vis for the in-house lawyer, they may be beholden to the structure of the entity they represent or work in. And yet, as you've rightly said, in cross-border deals, there's a lot of innovation required because you are trying to seamlessly deliver close a transaction that has multiple jurisdictions involved. So in 1 minute, give us your parting shots for legal readiness for the lawyer in these respective practices. Thank you.
Thanks. So luckily, we do have quite a number of, particularly the bigger law firms that are already operating in this space. So I wouldn't say that what a lawyer does within an international sustainable finance transaction is completely new or there's no experience around it. A lot of the domestic firms have done this work, and we tend to rely on a lot of law firms to help us implement the transactions in the various jurisdictions. I would say, as a lawyer who's involved in sustainable finance transactions, of course, your expertise is very key. You need to know, you need to understand these transactions, you need to understand these products. And the only way that you can do that is if you have a very good understanding. Build your expertise. There's a lot of information out there. There are a lot of courses out there on sustainable finance. You'll see some of the industry bodies like the Kenya Bankers Association, they do have a bunch of sustainable finance courses. If you look at the Loan Market Association website, they do have quite a lot of content and some trainings and courses. Your interest and engagement in a lot of these products is basically your involvement in the markets. Sessions like this where you come and converge with colleagues and hear about sustainable finance and what lawyers are doing on the ground and how they're putting structures together. This is part of growing your expertise and also your interest and knowledge in the various products. So I would say there's a lot of work and a lot of room actually for lawyers to be involved in these transactions, because as much as I did say that there are a number of firms that are involved with this transaction, but they tend to be a handful. Typically, we would see the big law firms in the various jurisdictions would be the ones ideally that we tend to see or tend to rely on for these transactions. There's a lot of room still. Sometimes we end up instructing the same group of lawyers. There's room for younger lawyers, for example, to step into those shoes and challenge themselves and provide support within the markets, the domestic markets, and help us grow forward. So a lot of room. I would encourage anyone who's interested to look into those online courses or any sort of industry engagements that widen your knowledge on these products.
Thank you, Lois. Let's see if there are questions in our chat room here. There's a question from Chala, but it doesn't look complete. Chala, if you're able to hear me, please pose your question because the one you've posted in the chat is incomplete. I think that individual is not currently available. Let's move on to the next session. Thank you so much, Lois. That was quite insightful. In case the panelists or even I myself and the attendees have questions for you and you're not able to make it towards the end, we'll address them to you hopefully via email and any other platform you may wish to use. But otherwise, thank you so much for that wisdom that you've dispensed. So we'll
Most
proceed.
welcome. I'm seeing
Yes.
a bunch of the team members, the attendees are saying they couldn't hear me too well. My apologies. I hope you could at least get something. But in the event anyone has any questions, please feel free to reach out to me for any clarifications that you may require post the session. Thank you.
So,
and thank you, Priska.
Lois. So, Lois, before you go, actually, a question has popped up. Let's delve into it. It's quite short. This is from Agwe Wanyoni. His question is AI likely to replace much of the service we offer for cross-border financing?
So in my view, well, I guess one time will tell. But in my view, currently, just based on where we are, and there's a lot of, I think AI is good with transactions or things that are generally very standard and vanilla. So I think the system is sort of trained to populate certain responses to certain questions. So on that basis, I would say no currently, because as I have said, there's a lot of, you have to understand the project, you have to understand the products. The various jurisdictions have different compliance and regulatory issues that you need to appreciate, and those also keep changing. So I wouldn't say that technology by itself would replace a lawyer's role in a cross-border finance transaction, because there's a lot of human touch and innovation typically required in a transaction. So I think for now, maybe there's room for all of us to be involved in these transactions. Let's not fear AI at this stage. I would say we are still on safe ground currently.
Thank you. I think you've just marketed banking to some layers who may be trying to figure out which areas to choose. At least we are still safe for now, based on your reassurances. Thank you, Lois.
You're most welcome. Thank you. Bye.
Bye. Thank you so much. So moving on to our next topic, we are going to address, fintech being on the rise and contrasting it with how legally ready we are to address the vast changes that are happening in the digital finance space. We have none other than Ms. Wanjiru Irene Njeri, who is going to take us through this session. A little bit about her. She's a leading legal and regulatory expert in fintech and digital finance, and with deep experience advising on innovation, compliance, and financial inclusion, she's uniquely positioned to guide us through this session. Ms. Njeri, you're welcome.
Thank you. Thank you very much, Priska. Thank you for that amazing introduction. Good afternoon, members.
So
Am I
let's,
audible?
yes, very well.
Okay, that's
Yes, and the team here says the audible is good. So
all right.
let's
Okay.
delve right in. So to
That's
kick us off, just as with the past speaker, could you briefly define fintech for us? I know we may think we actually know what it means, but we tend to actually have skewed understanding of certain concepts because we think we see them everywhere, so we know what they actually mean. So for fintech, what does it encompass, and what sort of services and innovations fall under this phenomena called fintech? Thank you.
Thank you, Priska. On that, I would say fintech is generally the financial and technology. It's like the marriage between finance, the financial services, and the technology itself, which includes improvement in the financial delivery of financial services, innovation, and automation. We have seen a lot of growth, especially recently, with how our banking and our banks, our insurance companies have improved and automated their service deliveries. So basically, fintech is integration of technology by various companies, tech companies, banking companies, in delivering of financial services to their customers. And it blends finance and digital innovation to create new products, platforms, and experiences for both the business and also the consumers themselves. And this has also been greatly steered by the unique blend of mobile adoption. We have seen a lot of, in the technology industry, we have seen a lot of growth on mobile adoption due to the introduction of different machineries like mobile phones. We have laptops, and this has also created a lot of mobility, and also the technology innovations. Day in, day out, we have experienced different innovations and also investor interest. Most investors also want to be more efficient in service delivery. So due to that, they have gone or moved to fintech as opposed to the traditional banking system and traditional insurance companies and also investment firms, which also they have not also been left behind. They are also key players in the fintech space. On the innovations, sorry, yeah, on the innovations, on what spaces we are experiencing that. We have like digital payments and transfers. We have things like mobile wallets, which includes the Apple Pay, Google Pay. I think most of us we have also been able to interact with mobile wallets, especially maybe when you're doing an online order. We also have peer-to-peer payments. We have things like PayPal, Venmo, and also cross-border remittances, where you're able to pay at the comfort of your home. You're able to remit a pending payment through other online. And also we have things like buy now, pay later. We have seen we also have digital banking, where we have we don't actually have physical banks, but you are trading or dealing and receiving services from a digital bank. We also have a product like where we have lending and credit innovations, whereby people are able to to request for or apply for financial for financial assistance or loans, and they're able to they through using AI and the AI tools, they're able to score on your credit worth, on your credit scoring, and they're able to lend you money. We also have investment and wealth technology. Also in the insurance industry, we have the InsurTech, whereby the insurance companies, they're adopting to the technology of processing claims using AI. And also we have the regulation technology, whereby the fintech has assisted many companies in identifying and monitoring the regulations and compliance of particular regions. So with all this, we are able to grow in the new and improved world, I would say. And I would say it is the fintech is reshaping how money is saved, spent, and also issued and invested, making financial services more accessible, efficient, personalized, and more so decentralized. And we have seen also fintech has evolved rapidly across East Africa, from mobile money, we have digital credits, to cryptocurrency platforms and AI-driven finances.
Oh, thank you for that great introduction, Irene. Just actually what you've just said in your last statement, that there's this rapid growth and evolution of digital finance, really powered by AI and all these other innovative tools. So from your vantage point, what are the most pressing legal challenges that you've seen, happen across the practice areas that you usually address your mind to, really from the perspective of the fintech innovators and also on the side of the regulators? And how have you actually given, advice that has helped clients to overcome those challenges? Thank you.
Thank you, Priska, for that very good question. I think the biggest challenge, I would say, it's on data privacy, security, and the cyber risks that people are exposed in, especially the customers. So we have seen most companies facing legal suits because of, especially if they are not well guided on data protection and the laws and the regulations in particular jurisdictions. Because as we are aware, data protection and data protection is basically, it's different in various jurisdictions, and therefore as an innovator or even a fintech industry, it is also it's very important for one to understand the regulations on data protection, so that you are able to avoid any legal risk that you may find yourself in you don't want to find yourself in trouble, yet you're trying to invest. Then we also have anti-money laundering, fraud prevention, and then know your customer. Also, the regulations, they also vary. So I would say, mostly regulations, legal regulations in different jurisdictions is quite a challenge. It is quite a challenge for different regulators, because different regulators, we have different authorities authorizing this kind of service delivery, and with that you will also find that the regulatory there's also a lot of regulatory uncertainty and fragmentation, because many jurisdictions still lack fintech specific legislation, forcing like some of the startups to piece together compliance across banking, telecommunications, and the data regime, because there's no stability, because these are laws and regulations that are still coming up, and compliance becomes quite hard. So that's one of a major challenge that the industry is facing. We also have cross-border compliance and global coordination, because as you are aware, the fintech is trying to make the world, the globe itself like a global village, and it's becoming challenging, because different jurisdictions have different laws that different regulations are applied, and it's such a challenge for the legal, for a legal team, as you know, to advise a client. And also I would say there's need from the legal perspective to engage from the time with the whole team, from the time they are making the product, so that you are able to understand the whole concept. We also have AI and the algorithm transparency, because you'll find people have faced this challenge with algorithm. They are the ones that are almost dictating what product works best for you. And it's a way of also exposing your data, and creating your privacy feels, many people you'll find complaining that their privacy is no longer protected, yet we have laws and we have regulations in different jurisdictions. Like in Kenya, we have the Data Protection Act, and it is very advisable for the fintech industry, as much as they want to improve on the efficiency of their service delivery, to also comply with such. Sorry, Priska, you're muted.
Oh, sorry. Just to take you back a bit before we proceed, an attendee has asked an interesting question tied to what you said earlier. You were discussing about the various functions and the comfort that AI has actually brought to us. And you mentioned something about some of the insurance companies actually processing claims, but using AI-powered tools. So an attendee has asked that how would that actually work, and would it create a moral hazard? I guess they're coming from the perspective that, with an insurance claim, is it a human, touch actually still relevant?
Oh, thank you for that question. With that, we have seen most of the insurance companies have also invested very much in the regulatory technology, whereby they also monitor the regulations of various, they have invested in regulatory technology systems to improve on the experience with that kind of service of processing claims, because they to create also accuracy in what they are doing, and also in their underwriting services. So with the regulatory framework, as much as it might look like there's a gap there, where there will require human intervention, they have tried all they are working with the regulatory technology systems to try and close that gap. I don't know if that answers sufficiently.
It does. I think my takeaway from just this brief discussion is that our regulators have a lot of work to do, in the sense that the tech is evolving really fast, and most times the regulator is playing catch up, and then the question then arises that what capabilities do they need to actually build to regulate the already proliferated tools out there? When you talk of even just the e-money loans, you'll just find providers of these services really operating unchecked for the most part. And maybe it takes maybe an unfortunate scenario then to spark the regulators, promptness to address that. But thank you for that. It's really just an interesting space to watch, but your insights have been really, really enlightening. I guess maybe now really to distill this further now from the lawyer in the law firm, in the government institution, or in-house, give us really 2 core tools that you feel the lawyer needs to equip themselves with to embrace this ever-changing landscape of fintechs and the innovation that's really related to it in closing. Thank you.
All right. What I would say, fintech companies are widely using AI, and from fraud detection and credit scoring to personalized financial services. And this, what does this mean to lawyers? What it means to lawyers is in advising these fintech companies, one must grasp how these systems work and the legal framework that governs them. You need to be able to understand, by the time they approach you, you should be knowing how their products work and being their systems, and what framework governs such companies. And also, I would say the regulation technology which has transformed compliance. I would say it's like real time know your client checks. Lawyers need to understand that these tools, both legally and operationally, they need to understand these tools, both legally and operationally, in order to be able to advise on implementation of such tools and governance and the risk, and also mitigate on the risks that are involved.
Thank you, Irene. A personal follow-on on that, does that mean then that, aside from spending 5 years in law school, for Uganda, you do the 4 years in law school and then you'll do the bar for a year. Now, when you say let's also learn the tech, does that mean we need to, go back and enroll for an IT course? What is a shortcut that you would see that would catapult us to actually be at par, with the players in this space? Because speaking for myself, you'll find that if you're representing or advising a fintech client, it is in their world. There's a lot of jargon involved and technical, notions in there. And as a lawyer, it can look like just this web of, new things that you're coming across. In your own, experience, how have you actually navigated just getting abreast to that? Did you enroll for an IT course, or are there providers of specialist courses for lawyers, that has a hybrid with the IT and also the law, just for our benefit? Thank you.
Really, no, I wouldn't say as a lawyer you need to go for extra training in the IT field. I would say, and what personally I have done is working closely together with these fintech companies, working with their teams to be able to understand the product that they are bringing into the market, so that you are able to understand on what regulations apply, and to be able to also guide them from the onset, instead of instead of firefighting when the product has already been launched in the market, you work with a team from the point of production to the back end, not just from the customer face, but also on the back end. Because what I would say, Priscilla, that in essence, AI literacy and regulatory technology competence is no longer optional. I would tell everyone, as a lawyer, this is no longer optional. It's foundational for effective legal counsel in the digital finance. So if you are totally invested in the digital finance, you really need to go and work. You work as a team, so that you're able to understand, but you don't have to necessarily enroll. It could be an added advantage for you to be able to understand what this technology is about, but also working with a team to be able to understand exactly what they're introducing to the market. You are able to offer your legal expertise.
Thank you, Irene. Let's see if there are questions in the chat room, aside from the ones I had seen earlier. I don't see any at the moment. So in the meantime, we'll proceed to the next session. Thank you very much, Irene, for the wisdom you've shared.
Thank you.
Given us a lot to chew on. Personally, I'm here debating, should I pay for the IT course or not? I'm joking.
Thank you.
Thank you. Let's proceed to our next speaker. So our next speaker is Dr. Hilda Topachu. I hope I've not butchered your name. She'll be taking us through our next topic, which is titled Green is the Future, really with the focus of ESG, climate finance, and the legal profession. And as you may recall, this is in a backdrop of getting us legally ready to embrace the novel issues that are cropping up each day in this banking space. So Dr. Hilda, a bit about her. There's a long list of achievements she has obtained under her belt, but I'll try to be brief. Otherwise, the whole session may be taken up with just her achievements. So she's a scholar and a creative solution strategist with a passion for a holistic bottom-up approach to legal and policy development and its applications for meaningful socioeconomic progress in our society. She holds a degree of Doctor of Philosophy from the University of the Witwatersrand with experience and publications on matters pertaining to international trade and business law, policy, and market regulation. Currently, she's the Research and Publications Officer at the Law Development Center, taking on the central role to lead and coordinate meaningful research activities on areas of the law at the research unit in the Department of Law and Reporting. So her value in green finance and the green future is shaped by her experience in the academia and also with small and medium enterprises and the complexities associated with the asymmetry within international and local regulatory market systems. Her work also bridges policy, trade, and the cross-border market regulation, giving her the edge to unpack our role as lawyers in the regulation of the finance industry in addressing the climate crisis that we have today. So in a nutshell, she's a trade law expert in her own right and a stellar researcher, known really the best person to address us on this. So Dr. Hilda, you're welcome. We are honored to have you with us.
Thank you. Thank you.
I hope I'm audible on your end.
Yes, you are. Can you hear me?
Very well. Thank you.
Thank you.
Yes, so to kick us off, and really just on a foundational aspect, really ESG, I know we've had this term over and over again. Our first speaker also introduced us to some of the aspects on ESG. So how is this different from your usual general environmental and social regulation? And this is really for the benefit of the younger lawyers and even the more seasoned experts really to start us off on the foundations of ESG. Thank you.
Thank you, Priska. To define what ESG is, I'll ride on the Uganda Bankers Association statement that ESG is the new kid on the block, all right? And it's an acronym that stands for environmental, social, and governance factors that affect our businesses, okay? But when we look at these factors and compare it to, let's say, corporate social responsibility and other tasks or activities that were taken on in the past by companies to protect the environment, there may not be much of a distinction, but what makes ESG stand out is the fact that there has been a prolonged progressive move to require companies to first of all, to take on good practices that are geared towards sustainability. Our first presenter had already discussed and explained to us what sustainability is. It's really, it does not only focus on environmental protection, but extends beyond environmental protection to embrace both economic growth and the well-being of the people and environmental protection as well. So when we are to understand the significance also or even differentiate ESG from corporate social responsibility and environmental protection, we need to go back to the point at which ESG became a very fundamental, not really requirement, but a very fundamental part of business practices where companies are expected to take on initiatives that are meant to not only promote profit generation, but also to protect the people or ensure the well-being of the people who are benefiting from their resources, whether it is through the supply chain, the supply value chain, or through the proper consideration and protection of the rights of their employees, or the protection of the environment within which these companies are operating. So when we look at, let's go back to the year 2000, we're looking at the Millennium Development Goals, and then we progress forward to the Sustainable Development Goals of 2015. We realize that there are 17 sustainability goals that are in place, including Goal 17 and Goal 13 that are specifically geared to a clean environment and climate action goals. Now, with that, we realize that over the years, there have been a push to ensure that human protection or the well-being of the society, the well-being of the people, environmental protection, and economic growth should be blended so that profit should not be the driving force. So yes, so ESG in a nutshell is all parameters or pillars that can be looked at, or guidelines that can be looked at to gauge the sustainability of a company in terms of its operation now and in the future. How is it operating in such a way that it is able to produce or generate profits, but is it taking care of its employees well? How about the minority shareholders? How about the shareholders' views as far as corruption is concerned, as far as bribery is concerned, as far as the reduction of greenhouse gas emissions is concerned? How about, is it only focused on generating profits and then disregarding all these other issues? I draw back onto a report that was published sometime in 2004 that was titled "Who Cares Wins," meaning if you care for the environment as an entrepreneur or as a business person, if you care for the people that are benefiting from your resources or who are part and parcel of your project, if you care and you have values of your shareholders, then you are indirectly contributing to the success of your business. And when we peg that up to the various international regulations and instruments that have come up since 1992, we go back to the United Nations Sustainable Development Agenda 21, and then we come to the Kyoto Protocol, the United Nations Framework Convention on Climate Change, and then to the Paris Agreement, and all these elements that come in relation to sustainable development. Yes, we need to promote growth, promote industrial growth, promote developmental initiatives, but at the same time, in so doing so, we should be mindful of the environment, we should be mindful of the people around, we should be mindful of the future generation. So yes, ESG in a way is different in the sense that the three different if I can call it maybe general, the three different factors that encompass so many aspects of society have been integrated together. And in some instances, for us, like for that in Uganda right now, we do not have any specific regulation. So it is more of voluntary compliance in quotes. But on the whole, there is a concerted move both globally and nationally towards embracing a holistic approach to business operations. Thank you. You have been muted.
Sorry, that was a technical glitch on my end. Thank you for the great introduction. And really probing further into the ESG aspect and now tying it into climate finance, I see that there's a lot of uniqueness then that is required when one is really advising on these types of transactions as opposed to the traditional types of financing transactions that we typically see. So there's room for legal innovation, I guess. So from your perspective, what type of innovation do you see that is required in these transactions? And this is really for us to, of course, equip ourselves and become better practitioners. So your guidance and insights would be really appreciated. Thank you.
Thank you, Priska. Now, as I said earlier, ESG may on the whole not be a new concept in a way, because when we look at it from a Ugandan perspective, you find that from the social perspective, we already have laws that are in place. Law, for example, the Employment Act, we have the Data Protection Act, we have the National Social Security Fund Act, we have the Employment Act, and when you look at specific provisions within these laws, there is already protection of the individuals from an employment perspective, and even looking at their future well-being, all right? But then also when we look at it from a governance point of view, we realize that from the Companies Act and the consolidated code, yes, the consolidated guidelines that have come up that have been established by Bank of Uganda in a bid to ensure that there is a disclosure, there is a specific setup or rules that are meant to guide the governance of any institution, board meetings, risk management, conflict resolution, and things like that. There is already a system in place. But even if you look at it from an environmental protection point of view, we have the National Environment Act. We have rules and regulations that are meant to guide waste management. We have rules and regulations to guide the management or to avoid oil spills. So literally, we do not, at the moment, we cannot say that we do not have laws. But maybe in my view, what I would see is that because this ESG encompasses so many aspects, the challenge that would be in enforcing it is that once you have a disintegrated regulatory system where each institution is involved in either developing its own laws, or each organization has the mandate to develop its own kind of standards without any umbrella regulation or institution to give oversight or guidance, then the market remains segmented. The market becomes a little bit hard to regulate and even ensure some kind of convergency and harmonization in the way things are done. That in itself makes it hard or difficult to predict the kind of business relation or investments that can take place within such economy. Now, leave alone that where we have regulations and standards spread out in different institutions or within different frameworks, even enforcement becomes an issue. But also, what about awareness creations? Yes, even if we came up with one law or one institution that is meant to give a general oversight on what should be in terms of disclosure, in terms of compliance, the question that really still comes out is that do our people get to know these things? Because as we speak now, we have the National Climate Change Act is already in place. We have the regulations that were recently launched, and still the question that the issue that comes back to us is that there is limited awareness. So for me, one of the things that I would suggest in terms of legal innovation would be not to depart completely from what is already on the ground, but perhaps come up with some form of unified, we could identify maybe one institution that can take up the lead. Maybe Ministry of Justice could take up the lead, of course, in partnership and collaboration with the different institutions, to develop a specific set of regulations that can provide the overall guidance on how and what should be taken into account when it comes to compliance and disclosure. And of course, we need to take into consideration the fact that certain sectors or subsectors are very sensitive when it comes to especially the banking industry. There are lots of issues that may not have to be disclosed, but then where do we draw the line? So going forward, for us to go to ensure that ESG is not an individualistic, voluntary a form of procedure, it should be made mandatory. Of course, from a business perspective, the question would be, what are the compliance costs for a business owner, especially if it's a small scale or small scale business enterprise? Are we only looking at ESG from the bigger companies that are listed maybe on the stock exchange, or are we looking at ESG from an SME perspective? So there are a lot of dynamics that need to be taken into account, so that by the time such a regulation is coming up, it is not going to be again an impediment to investments and financial flows. But we can't run away from the fact that if it is made mandatory, there is a possibility that that kind of regulation provides the platform through which accountability can be required, and companies that are not fulfilling their obligations as far as maybe the well-being of the employees, the community is concerned, are put to account. Thank you.
Thank you, Dr. Hilda. That was quite a comprehensive response. Delving further into what you've just mentioned, really the proposal for ESG compliance to be driven by some regulatory reform. Of course, a consequence in my view then would be that companies or even any other enterprises would need to then drive their compliance up. Now, thinking of greenwashing, which is really of a growing concern worldwide, we see that companies then will tend to make false or exaggerated claims saying that, they are, sustainable conscious and their products, are tied to all these really great notions under ESG, whereas that may not be the case. So as lawyers, how can we protect our clients from the legal and reputational risk that may arise from these misrepresentations tied to ESG? And really from the angle, especially of the SMEs that are trying to tap into this finance that comes tied with the ESG requirements. Thank you.
All right, thank you very much. As a lawyer who is in charge of advising, especially an SME, we are in an era where we have access to the most of service providers or product suppliers have access to the internet. And you find that a company may copy and paste vision statement or mission and values and all that without taking into account the reputational risks that are going to be associated with such aspirations. Now, for example, a company that says this product is has been produced from 100% recyclable material or biodegradable material, or puts an inspiration to say by 2030 we are going to be net zero. Yet we are already in 2025, but in their operations they are literally not even 5%. Let's say maybe from an energy efficiency point of view, they are not even 5%. The kind of energy they're using is not, does not, the renewable energy that they're using does not even constitute 5%. Or when you look at the way they are managing their waste, or maybe let's say paper waste, or even any kind of waste within the institution, or the kind of packaging that they are using, are they being deceptive in terms of the information they're giving out to the public? Because at the end of the day, once you provide, let's say, for example, you develop your strategic investment or strategic framework document or your business plan projecting your 5 years program, action program that you intend to take, and then also the investment plans and the things that you want to do. What is it that you're telling the public? Are you sugarcoating? Are you greenwashing? Are you trying to create this impression that you are so good, yet in reality, you are doing the opposite? Now, we have seen within the public domain, there's already information that shows some banks and even some electronic companies and even some beverage producing companies have over the years been sued for deceptive practices, for putting out false claims. Yet when research and investigations were done, it was established, for example, Coca-Cola and even Samsung, the instances where questions, they were called upon to come out and be transparent with regards to, especially for Samsung, with regards to the disposal of a specific brand of telephone, which was found to have batteries that are very faulty. Now, the advice that one would need to give such a client, of course, depends on the market. We find that if we are in a market where the consumers are not well informed, they could also be well informed, but they're also not litigious. So yes, people can may be free to express themselves, but we do not know who is enjoying that service or who is partaking of the benefits of the products that have been used. They may not be national, but they may be not within the country. They may be a global client who may choose to sue. So for any SME or any client, the best would do is one should be in a position to do a proper cost benefit a risk analysis and ensure that by the time they go and develop their investment plan or their strategy documents, they try and project and establish whether or not that which they're telling the public is likely to affect them in the future in terms of costs, in terms of legal costs, in terms of reputation, and in terms of profits. And in one way or the other, they cannot run away from the fact that maybe they need to inject in finances to ensure that they get the proper and appropriate advice on how best they can marry their desires to become compliant and support emissions reductions or support environmental protection without having to be engaged in false or deceptive business practices.
Thank you, Dr. Hilda. I could listen to you go on and on. I
Yes.
think that was really quite a well-reasoned answer. And my personal takeaway then is that as a lawyer, I have to shift from the mindset that the client needs to come to me with a problem, but there's proactiveness required to actually probe with these clients that we represent, that let us actually be involved in your investment planning. Let us actually double check some of these, claims or statements that are going out to the public and make sure that everything is airtight. So really that wraps up the last question I actually had, that was actually on capacity building efforts. Hope that is actually an accurate summary. Really the proactiveness for us to reach out to the clients and walk every step of the journey with them, as opposed to waiting for, the egg to break. And then we are really doing the damage control at that point. So that was really insightful. I don't see questions currently in the chat room, but we'll see how that goes at the end of the session. Thank you so much, Dr. Hilda. We really appreciate the wisdom you've shared with us today. Allow me to usher in our next speaker, Mr. David Benjamin Wasonga. He will be taking us through, the evolving role of in-house counsel in driving business integrity and transformation. And this is really from the perspective of the financial sector, adding on to what the other speakers have so far covered today. So a little bit about Mr. David Benjamin Wasonga. He is currently the company secretary and head legal of Akiba Commercial Bank PLC in Tanzania. And with extensive experience at the intersection of legal compliance, governance, and institutional leadership, he brings a valuable perspective on how in-house legal teams that are no longer just risk managers, but key players in driving transformation and business integrity. Mr. Wasonga, we are honored to have you. Thrilled to hear from you today. Welcome.
Thank you, Priska. Thank you very much.
Yes, I understand you have slides that you're going to share with us today. Kindly share your screen. Yes.
Sure. Just a second.
Sure.
Can you see my screen now?
Yes, David.
Technical glitches. Something is happening here. Oh. Can you still see my screen? Something has happened, just happened. Sorry for this technical glitch.
We can see your screen, but the presentation is not yet up.
Oh, sorry.
Oh, perfect. We can see the slides now.
Thank you, Priska, and participants for allowing me to share with you some insights on the governance, compliance, and risk in the financial sector, as well put introductory remarks. This is one of the areas which has become very crucial and it's one of the burning areas in the finance space, because it touches the core, or it touches the core pillars of the corporate or corporate institution, of course, the financial institution itself. So why this concept has become so important now? Because without proper governance, without compliance frameworks within an institution, the financial institution may collapse. This is why there are a lot of regulatory frameworks within the region, locally, at regional level, and even globally, just to ensure that these financial institutions do not collapse. For example, here in Tanzania, we have the Bank of Tanzania, which is the central bank that regulates the conduct of all financial institutions. We have a number of regulations, a number of circulars, number of rules, number of circulars that are given every month, just to ensure that the sector complies with what the law demands. So what are the trends currently? So what you're seeing now, or what you're witnessing at the moment, the focus in the space of finance at local and regional level, the focus is on operational efficiency. Sorry, something just went off here. The operational efficiency. The previous presenters spoke about the digitalization, and even Dr. Stella touched a little bit on it while she was presenting on the ESG in general. But actually, the current trends that we are seeing in the finance space is that the shift has been on the improving the operational efficiencies and focus more on the customer, that is customer centricity. These financial institutions are focusing on what really the clients or what the customers need in terms of or the services that they are giving, they are providing to the customers. They're trying to provide more personalized experiences and tailored services. And in all this move, you can see that digitalization has become very key, or is a key feature, or is a predominantly key feature that cuts across all the segments in the banking space or financial space. This is seen, of course, in the retail banking. You can see some increased emphasis on mobile banking. I think Ms. Wanjiru, while presenting fintech, touched a little bit on the transformation that is currently ongoing in the finance space. So in retail banking, you can see the emphasis on mobile banking, integration of the ESG. Dr. Hilda has spoken much about this, and I won't repeat. Of course, the digital transformations itself and the automation, as well as the consumer prioritization. I said earlier that focus is on seeing that customers enjoy what they really expect from the banks or from the financial institutions. But again, the same is also seen under SME. Yeah, but of course, as some of the key trends that we are currently seeing, some of these financial institutions are collaborating with fintech companies. You cannot escape from them, as they have actually kind of monopolized the sector. So a collaboration between the financial institutions and these fintech companies is very vivid at the moment. Of course, the policy and regulation development, as these other new things evolve, you can see also a lot of policies, a lot of regulations that are coming in, and the digitalization of the automation of SME as well. But again, as these things happen, there is also an issue of building capacity for people that are working under this. But of course, the same would apply to corporate banking. And in all these segments, that is retail, SME, and corporate banking, and even other segments in the treasury and all that, you can find that the transformation, especially on the digital part of it, the digitalization, has continued to remain a key player in all that. So what are we expecting? What are we expecting in all this? First, we are looking at where we are expecting much more convenience in terms of accessibility. Is accessibility to money, is accessibility to loans, but also expecting people to be time savvy. You know, the products that are being developed by these financial institutions or banks, what we are really expecting from these changes is that people will be saving time, no queuing at the bank hall, but people are just transacting through their mobile phones. But of course, that goes with the efficiency and reliability. We are expecting, as these changes occur, services will be more efficient and reliable. But again, as I said earlier on how we manage the customers. Customers have become so more sophisticated ever than before. So it is upon these financial institutions and banks how they manage the expectations of the customers. And of course, all this is because the evolving technological advancements. But again, the individualized payment offering is also expected in the future as we are evolving. But also accessibility, as I said before, which is the very, very important aspect of it. because at the end, what is expected is to have an access to money. But the analytics to perform better, the in-house units working day and night to develop various channels, to develop means that they address the customers' needs amidst all these evolving technologies. But again, a 24/7 digital business model. Customers expect to have access in all the time. There shouldn't be any things that prevent them from accessing their money, accessing the transactions through wallet banking and all that. So this is what really we're expecting as the involvement as just but again, the flexible infrastructure within the financial institutions, people are working on the core banking systems that are friendly, the core banking systems that address these technological changes. And you can see that there are so much updates on these core banking systems and other infrastructures that would enable smooth or seamless operations of these financial institutions. So what trends will affect the future of payments? I think my sister who was talking about the fintech touched a lot about this. The financial inclusion, we see this at both national and regional level, that the focus has been on mobile money, wallets, and QR code. You can access money, you can pay, you can do all that through your mobile apps. But again, the alternate payment methods, the credit cards and debit cards now are no longer dominant in the market as sectors adopted alternative digital payments. With the things like MasterCard, PayPal, Visa, and all that has really come to change. It's a game changer, really. But again, the non-traditional players, the e-commerce, people are purchasing, people are selling just online. So we are slowly moving from that traditional kind of banking, but things are just on the tips of our hands, like in the past. But again, the instant payments rails. Wanjiru spoke much about this while discussing on fintech and cross-border payments. Of course, this was touched, so I won't go deeper into that because of time constraints, as well as the digital wallets and adoption. So generally, that's the trend at the moment in as far as financial institutions locally and at the regional is concerned. So going back to what actually the core of the discussion, which is of course governance, risk, and compliance. So as I said, governance is very important, and these are the rules, sets of rules, processes, and policies which are must for proper functioning of the financial institution. So without them, a financial institution, a company cannot actually function properly. That's why every institution has them. So why does it matter? Why does it matter? Of course, it maintains the stability and integrity of the financial system, because you need to have these processes and policies in place so that you have a stable institution, a system that has or shows transparency, system that shows people are accountable. This the whole rationale of having governance mechanisms in place. Of course, to protect the customer's interests. Without these regulations, customers' rights may be prejudiced. So you need to have a system that protects them, safeguards their interests, safeguards their information, no disclosure of the information necessarily, and all that. Okay, so with regards to risks, of course, risks are many in the financial sector, and that anything that can give an adverse outcome, that is a risk in the bank. And there are so many risks. Some are internal and some are external. So of the internal risks, like this operational risk, you may have system failures, credit risk, defaults, liquidity risk, where the company falls short of the capital requirement, then also the fraud risk. But external risks, we have the market risk, where changes in exchange rates or interest rate occur, and you don't have a good system in place to address them. It affects the business. The reputational risk, Dr. Hilda talked about this in detail while discussing on the ESG requirements that actually now banks and financial institutions have moved on. Even the policies that are being structured, they tend to address these current trends in the world. But compliance risk, because if you don't comply, there are penalties, there are fines, and things like that. But again, cybersecurity risk, this was touched by Wanjiru while discussing the fintech. So all these are risks that are very likely to happen if you don't have a good risk framework within an institution. And compliance, of course, as the last part of it, is very important, because it's all about how we adhere to the laws and the industry standards and regulations, and of course the best practices that are there in the governing bodies. As I said earlier on, for example, in Tanzania, we have the Bank of Tanzania, which is the central bank. There are a number of guidelines, number of regulations, codes, frameworks, circulars, etc., etc. And it is very important as it protects the financial institutions from compliance risks, as I've just said, but again, gives you a framework to assess the risks within an institution. Also controls the testing and monitoring. Normally, within banks, there are those controls, testing and monitoring, which are made and reported to the committees of the board or the board itself, so that the board is well informed of what is going on. The same would be for reporting, as I've said, and of course it is important because these risk officers also provide guidance and conduct various trainings to the employees of these financial institutions. Risk officers may also be in-house counsels who also undertake that role. So in general, that is the importance why governance, compliance, and risk is important. But this is just in a summary. So going to the business integrity, I said these are ethical principles and practices adhered by the financial institutions in their operations, and of course, why it is important, or it entails the ethical culture, how ethical the institution is, how you are compliant with the laws and regulations, how transparent you are, the disclosures I have said earlier on, the information that you're disclosing to the shareholders for the protection of their equity, the confidentiality of the customers, and all that. So, and also how to do away with legal and regulatory sanctions is part and parcel of the business integrity as a component to this one. So when it comes to the transformation itself, to me, this is the rethinking and restructuring of banking operations, strategies, and technologies. Because all that I've said from when I started sharing with you these insights is about the operations and the strategies, and the emerging technologies, and how we adapt them. So business transformation would entail digitalization. I said there is a need now to embrace technologies, mobile banking apps, AI, blockchain, and all that. But again, customer centricity, I overemphasized on this because every financial institution focuses now on delivering personalized and convenient, seamless banking experiences. of course, innovation, how we embrace these innovations to solve the traditional problems. But again, it also entails operational efficiency. I said this, the kinds of systems you have in place to make the business, the operations very seamless. And workforce transformation, of course, the technological advancement, all these are form part of the business transformation. So how is this evolving role of an in-house lawyer, how this evolution occurs? So to me, the evolution, I can say, is a process of change in the legal practice within, that financial institution that passes through different phases. For example, traditionally, we used to have a lawyer who just knows what the law is and just gives or provides an advice. That is the I lawyer, or others call it the I model lawyer. He only knows the law. Of course, they are very reactive and compliance focused. But also, that is as far as the traditional in-house lawyer is. But when it comes to a modern in-house lawyer, that we think is matches these evolving technological advancements at all. So we look at him as someone who has, is more strategic, more involved in the business, has become a strategic partner. They form part of the business itself. They're involved in strategic business decisions. They are not only compliance focused, but they are steward of the institution. So in the end, how do we then drive the business integrity as in-house lawyers? Drive the business integrity and transformation in an evolving financial sector. What I can say is to first to integrate the digital technologies into all areas of business. That is to embrace the technology, because embracing technology is very, very important. And the emerging technologies like the AI, the blockchain, of course, that offer opportunities for banks to improve efficiency and to enhance the customer experience. But again, there is adapting to evolving regulations. I said earlier, way back, we didn't have things like cyber security, data protection, and all that. So as an in-house lawyer who actually in the past did not know about those things, they need to know about these things to have a data protection officer within an institution. So we have shifted from that traditional role of just knowing the law and advising, but actually getting involved to the business itself, But again, we need to drive the business strategy, as I said, be part of the organization's strategic plan and adopting the new business needs and what customers increasingly demand from it. But again, we need to collaborate with fintech companies. Yeah. So in a nutshell, that's what I would say, Priska and other participants think were worth sharing in terms of the governance, risk and compliance, the evolving of in-house counsel in driving the business transformation and integrity. So thank you so much.
Thank you, David. That was quite interesting. My follow-on question is really broad, speaking from the private practitioner's perspective, and what tips you could then share with some of us that are in that space, how best now we can actually support in-house, counsel, because as you may understand, most times there's that collaboration that happens between external lawyers and the in-house lawyers. Because as you rightly pointed out, the in-house lawyer's role has evolved so much to extending the expectation of understanding the business, embracing the tech, and making sure that there's uptake across the several departments in that entity. And yet, as a lawyer in the law firm, I'll really wait on, you know, that emergency that David, you may say that, okay, now there's just this one thing. So to the extent that you're becoming less reactionary as in-house counsel, what's the changed expectation then for the lawyers in private practice that support the in-house teams? Thank you.
Thank you, Priska. Of course, to me, the external lawyers also need to be business partners to their clients. You know, nowadays it's not only about just providing a legal opinion, but actually knowing what your client needs, what are the client's needs. So the law firms or whoever that works with the banks or financial institutions as their clients, first they need to understand their clients' needs. And by understanding their clients' needs, they may be in a position to advise accordingly. Just imagine you are advising on a transaction for a syndicated, let's say, loan, but you're putting so much, or you are becoming too much legal instead of giving, you know, the real solution to that transaction. So first, know what the client needs, but again, they need to think business. In where I come from, for example, sometimes the board doesn't really care about whether you win a case or don't win a case. But what matters in the end is the bottom line is what? The numbers. Is there a value for money from the shareholders? Value for money for the shareholders? Because if you win a case, then you have a decree, then you fail to execute a decree. That is as useless as losing a case. So they should be business focused, business minded, but again, they need to be proactive. They just not need to wait until their clients ask them for an opinion. If there are trends that are happening in the industry, they need to update their clients, that is the financial institutions, in terms of what is happening. And by doing that, of course, you keep the clients close, and even you can strike much more deals. But again, when you give solutions or when you are working with them, what you provide to them, make it tailored to them, clients-based solutions, so that even if someone asks for they ask for an opinion, you bill according to the funds that they have. Bank A may not be as good as Bank B in terms of their financial positions. So know what the clients want and know their positions in advance. But most importantly, keep them up to date. The in-house counsel sometimes may be busy with the business of the institution and not get very much not get more details in what is happening in the industry. So as an external lawyer or as a law firm, you need to know these dynamics and update or keep updates to your clients as when it is needed. Thank you, Priska.
Thank you, David. Just one follow-on from what you've just said. You mentioned briefly that as external lawyers in law firms, we need to understand the client's position and give tailored advice. And this is really actually more of a comment that then you find that sometimes we walk a thin line between really telling the client what they want to hear so that they actually have the comfort that I can rely on an opinion that matches what I want, vis-a-vis actually, being objective and saying there's actually legal risk, however minute or severe, if a certain course of action is taken. So I just find that most of the times we get labeled as being rigid or too risk averse for the client's taste, and yet that's really the crux of our training and background, that we're supposed to see everything that could go wrong how do we actually strike the balance then? Because at the end of the day, if a client relies on the opinion and then to their detriment, there's of course repercussions for the law firm and, you know, reputational wise and also professionally for the individual lawyer and also the team that put together the advice. So help us navigate just really that key pain point, because there's always tension when it comes to really bargaining on the legal, what can I say, boundaries of what's possible and what's not. Thank you.
Thank you, Priska. It's always challenging when it comes to balancing between legal and business. And as you have rightly put it, not all the time the clients or these banks or financial institutions will accept your opinion. But as lawyers, of course, the law is the law, because the opinion addresses a number of things, from the business, from the risk part of it, and if it goes deeper to give you a better way forward in terms of what is required. So striking a balance between what the law says that is legal vis-a-vis what the client wants or what the business is has become a little bit challenging. But my view has been that you need to, as lawyers, we just need to tell the client that this is the position, but if you take it or you don't take it, then these are the consequences. But of course, without compromising your position as a lawyer, because we are all accountable to the opinion or to the advices that you are giving our clients, and we are not pushed to the limits that no, you have to advise your client according to this one, and if they don't take the advice, then the consequences will be that way. So I think the proper way to do it is giving them the right position of the law, of course, by also taking into account the business needs. But if there are somehow compromises here and there, you need to see where we need to see where it weighs and which side actually needs to be addressed properly. Thank you. I don't know if I've answered that correctly. Thank you.
Thank you, David. Yeah, mostly. I just have still some follow-on questions, but I guess we'll take it offline. But I think in totality, you've done a great job, as well as the rest of the panelists. I'm looking through the chat room to see whether there is actually any questions that weren't answered before. I've seen one that's addressed to all of us, and this is from, let's see. I can't seem to see the name now, but the person was asking about the need for the regulation of virtual assets. And I think they touched on Rwanda and Kenya having a bill already in place. Their question is quite broad, so I'm not sure what the specific question is there, but I guess if any of us can touch on just the virtual assets in general and whether in your respective jurisdictions there's any movement in terms of regulatory shifts that are happening, please feel free to chime in on that. Thank you.
So maybe I can take it, but for example, in the space of cryptocurrency in Tanzania, there are no very clear rules currently, but the central bank is still researching on how best this thing can be managed. So from time to time, the central bank has been giving cautions to the public not to use them. because currently we don't have that piece of legislation which clearly addresses such platform. But I think in the future, and as times go by, there will be in place a platform that also will address the use of such kinds of virtual transactions like the cryptocurrency and all that. But I don't know in other jurisdictions like Uganda and Kenya. But as far as Tanzania is concerned, I think that is the position. Thank you.
Thank you, David. Scoring through the chat room, but really for Uganda, yeah, there's no regulation still, and I think the general perception really from the public is, I think, one of just of mystery still surrounding cryptos in general and any other virtual assets. So it's pegged on, I think just the negative stories that come out with people being fleeced of their money and etc. So I think even right now, even with the regulatory temperature, it's not really warming up so much to that space yet. But I do know that there's active involvement. People are actually involved in the crypto space, but really highly unregulated. But I guess that will really inform another discussion for another day. I think I'm not seeing any more questions for now. And I think since we're time bound, I would really like to invite Gabriel to wrap us up. But before Gabriel steps in, just a vote of thanks from myself personally and everyone in attendance to all our esteemed panelists. We are very grateful for the time you set aside out of your busy schedules to address us on these really key and topical sessions that we've just delved into. There's lots to take away from each and every one of your sessions. And I'm sure that we'll have many more of these engagements. This is really just to really tickle our minds and see how much value we can actually add to the legal practice in our respective jurisdictions, which then would feed into the growth of East Africa as a region. Thank you so much. And at this juncture, I'll invite Gabriel Achai to wrap us up. Thank you.
Oh wow! Thank you, Priska. It's really been an incredible session, and thank you so much for your very stellar moderation that has kept us engaged, and it's incredible to see that for 2 hours you've maintained the consistency of over 200 participants on this session. So kudos to you, Priska. Well done. You couldn't have done it any better. Special thanks to our esteemed panelists, Dr. Hilda Thopachu from Uganda, Mr. David Benjamin Wasonga from Tanzania, Ms. Wanjiro Irene Njeri from the Republic of Kenya, and my good friend Lois Erambo from Kenya as well, who joined in for this very wonderful conversation. It's really been eye-opening, and it's really motivated us to have another series because from this conversation, you could tell that there's quite a lot to unpack that we should aspire to unpack. So I urge you to be on the lookout for our subsequent webinars on banking and finance, ostensibly in the March of August or September. For those who joined us a little later, this conversation will be happening as well at our in-house council convention in the Republic of Rwanda, Kigali. You come and join the largest community of in-house council in the beautiful city of Many Hills on the 28th and 29th of August 2025, and will be at the Marriott Hotel. So if you're in-house counsel, you're working for a bank or working in-house in any corporate institution or government, please, this is your conference. We have over
300 participants that will be attending that particular session. So you want to be part of it, network and grow your reach. Also, conversations of this nature in line with banking and finance will be taking place at the convention. So you do not want to miss that for anything in this good world. So with that said, I wish you a very, very lovely afternoon until we meet again. Next week, we'll have a French session. So for our French speakers, we'll be taking you through a session in French. So you look out for that session coming in next week on Tuesday. Otherwise, from us at the East African Law Society, we wish you a very, very lovely day. And for now, I'll give it to Priska to now wrap it up. Priska.
Thank you, Gabriel. I was actually putting up my hand just to make sure that we get certainty on whether there's going to be a recording shared for the attendees, and also for David's slides to also be forwarded as well.
Yeah, certainly, Priska. Colleagues will be sharing the slides via email, but also the session has been recorded on our YouTube channel. Please like and subscribe on our YouTube channel at East Africa Law Society. Wishing you all a very lovely evening until we meet again. Goodbye.
Thank you, everyone.
Thank you,
Have a
Gabriel.
lovely day.
Thank you.
Bye.